Welcome back, business law students. Today we are talking about our textbook, chapter 20, which covers basically sales, contracts, the Uniform Commercial Code, uh, and then we'll just touch on international contracts at the end. This outlines what we're going to talk about today, so I won't go over that, but UCC, basically the Uniform Commercial Code, you may recall that there are a group of scholars, academia that have came up with a simplified rule of contract law for the sale of goods or for leases. And then each of the 50 states in the US, and keep in mind we're talking primarily about US law in this business law course, has adopted the Uniform Commercial Code into their statutes. So it is now the law in all of the 50 states and the territories of the United States. Why do we need the UCC? Well, many, many years ago, the statutes or rules or judgments regarding contract law might have differed from one state to the other. So if you were buying something from out of state or selling something out of state, you might have a different result. So there was really a push to have uniformity in the laws. So the Uniform Commercial Code was passed. It controls contracts. See, general contract law, that just means judge-made law and statutes other than the Uniform Commercial Code as adopted into statutes by the legislature. So contracts, general contract law that already exist might go for real estate, service contracts, et cetera, et cetera. While statutory law, UCC Articles 2 and 2A, will go relate to the sale and lease of goods. Well, there is an international equivalent that is fairly similar to the UCC because your customer in the Philippines is going to say, wait a minute, I'm not in the US, I don't follow the UCC. Well, the UN came up with a good piece of proposed legislation called the Convention on Contracts for the International Sales of Goods. And it's usually the UNCISG or the CISG. And it's similar to that, but it applies on sales between different countries that have adopted the CISG. Now, so here's some important terms for you to know. It's very important under the Uniform Commercial Code. What's a sale? What's a merchant? What are goods? And what's a lease? Well, let's uncover that. So the UCC, Uniform Commercial Code, applies to the sale, passing of title from one to the other, of goods. And let's call that an item, a piece of something of real property that must be tangible and movable between merchants. What's a merchant? Well, if Walmart is purchasing pants from Levi's, those two are both merchants. So the Uniform Commercial Code applies to sales and contracts between those two. However, when you go into Walmart and buy some Levi's, you are not a merchant. You are a consumer, an individual consumer. So the UCC does not apply to that sale. Let's say that again. So the Uniform Commercial Code does apply to the sale between Walmart and Levi's because those are merchants engaged in business, usually considered more sophisticated, more practiced, while your purchase from Walmart of Levi's is not under foreign Uniform Commercial Code because it is not a sales transaction between merchants. 2A, leases. It's similar to goods, but it has to do with lease. For example, you lease a car. That comes under Article 2A, where Article 2 applies to the sale of goods. Now, what if there is a state law conflict between the UCC and judge-made law or other statutes? And this is important. There might be a test question on this. I can't remember. But anyway, when Other state law, a judge-made law, which is known as common law, or other statutes conflict with the Uniform Commercial Code that has been adopted by the state, the UCC controls, it overrules, supersedes the conflicting law. However, if the UCC does not address the issue before the court, then the other law, common law or other statutes, apply. Now, again, this is partly definition, part not. So we already talked about offer acceptance consideration, right? Under regular contract law. Now we're talking about those same concepts under the Uniform Commercial Code, the sale of goods or a lease between merchants. All right, not with a consumer. So the offer under the other contract terms, non-UCC, it had to be definite, but under the UCC, it can be a little bit indefinite, but the quantity has to be stated, the price has to be stated, etc. It has to be relatively clear. But even if it's a little vague on a few things, it could still be considered a valid offer under the Uniform Commercial Code. Now, what if I try to pull back my offer before it's accepted? Yeah, you can do that unless in your offer you said something like this is valid for 60 days. Then you can't pull back your offer for the 60 days. What's acceptance? You remember that acceptance essentially in the non-UCC context is you accept exactly what the offer was. Or if you come back and say, add or change some terms, that's considered a counter offer. Now, in the UCC, the drafters knew it's so often that one company issues a purchase order, the other one issues a sales order acknowledgement, and they have different terms. So the UCC drafters knew in order to just do business, to do commerce in the US, we've got to leave a little wiggle room, or else people will always be backing out of contracts saying, well, the acceptance wasn't exactly the way of the offer. So the only rules are the acceptance has to be communicated back, for example, back to the person that issued the offer, purchase order, and the mirror image rule, they have to be identical. Offer and acceptance doesn't apply. Well, consideration, pretty similar to common law. Now, let's look at one of the UCC provisions as opposed to the common law. How are they different? The rule we already learned as opposed to the new Uniform Commercial Code rule. Right? Bear with me while I share. I hate those Liberty Mutual commercials, but that's another issue. All right, here we go.
In this video, we'll continue to look at how the Uniform Commercial Code, the UCC, modifies the mirror image rule. If you recall, in Part 1 we looked at additional terms, such as where a buyer orders 10 apples for $100 and the seller's acceptance says, sure, 10 apples, $100, and we'll be wrapping those apples in plastic. And we learned additional terms can become part of the contract unless they materially alter the contract, or if the offerer says you can't add any terms to this offer, or finally, if the offerer objects to the additional terms within a reasonable amount of time. But now let's say we have two merchants, and a buyer decides to order some tires. She orders 10 tires for $500, and she has a provision stating that any dispute must be litigated within 3 years. In other words, if a party discovered a problem in connection with the contract in 2015, she would have until 2018 to commence the lawsuit. And the seller states that he accepts the offer, but his acceptance form says, sure, 10 tires for $500, but any litigation must be brought within 1 year. So here we have different or contradicting terms. Under the traditional mirror image rule, because the seller's terms are different from the buyer's terms, we would not have a contract. But the UCC tells us that even if an acceptance doesn't match the offer, we can still have a contract. And there are three major approaches that courts take to deal with contradictory or different terms in an acceptance. And the most common approach is called the knockout rule, which we'll be looking at in this video, and our two other approaches are the fallout rule and to treat the contradictory terms the same as additional terms. Under the knockout rule, the contradictory terms are going to knock each other out. They're going to be taken out of the contract. We have 10 tires for $500, but the contradictory terms should be eliminated under the knockout rule. Now our contract has the terms that the parties agreed on, 10 tires for $500. So far, so good. But how long do parties have to commence a lawsuit? Remember, the court just knocked those contradictory terms out of the contract. The answer is that the Uniform Commercial Code, that statute, will provide us with the missing terms. In this case, the UCC would probably tell us that the parties should have 4 years to commence a litigation. So if there's a problem in connection with the contract that's discovered in 2015, parties will have until 2019 to commence a litigation. If you have any questions about the UCC,
I like that. That's a great explanation of the difference between how the contract law we've talked to up to now, if you don't accept exactly what the offer is, then your acceptance is not really acceptance, it's a counteroffer. But under the UCC, there can be some exceptions, and as long as they're not the really big material ones, price, quantity, delivery date, then it's still a contract. Now, let's move to a concept called the Statute of Frauds. Well, why is it called the Statute of Frauds? Well, theoretically, the key here is that courts wanted to stop fraud and say, which type of contracts do we require to be in writing? So somebody can't just later come to the court, commit fraud, and say, oh, yeah, this was a contract when it wasn't. So, under the Statute of Frauds, if something is a sale of goods, 500, or lease, payments more than 1,000. You remember what goods are. It's not real estate. It's not your house. It's not land, but it's goods. It's something tangible, can be moved. Phones, bread, etc. So it must show a writing that shows they intend to form a contract, and it must be signed by the party against whom enforcement is sought. In other words, if you're suing somebody, they must have signed or digitally accepted it. Okay? I'll let you read those exceptions on your own. Now let's say that we get to court. And you remember the knockout rule where the judge said, wait a minute, under the UCC, you guys agreed to 2 of the terms, but the third one you disagreed. So the judge has got to look at the contract and say, what did the parties really intend? When can the judge look at just the contract? And sometimes that's termed the 4 corners rule. 4 corners of this page, a contract, a document. When is a judge limited to only looking at that? And when is a judge allowed to look outside of the contract? Testimony, that's not what we intended. Emails, this is what we intended. See? Well, that's called the parol evidence. Can the judge look outside the contract and consider other evidence? The way I remember parole is when someone's on parole, they get out of jail. So when we look at parole evidence, you can get out of the contract. That's an easy way to remember it. All right, let's look at a video that explains it, and I think more eloquently than do I. Bear with me.
In this video, we will introduce the parole evidence rule. In general, the parole evidence rule provides that once a written contract's terms are finalized, evidence from outside the contract is prohibited for purposes of changing the terms of the contract. More specifically, the parole evidence rule applies to so-called integrated written contracts, that is, finalized terms in a written contract. The rule excludes outside or extrinsic evidence, such as prior negotiations or discussions that would be used to contradict or change the finalized terms of the contract. But keep in mind that evidence from outside the contract might be admissible for purposes other than contradicting or changing the terms of the contract. Contracts are often negotiated over time, and the parties might discuss all sorts of terms and conditions, such as payment terms, relevant dates, and each side might have different views as to what should be agreed on in the final contract. At some point, though, we hope the parties will reach an agreement, and they'll sign a contract with final terms on which all parties have agreed. Now, if this is an integrated contract, meaning it has all the final terms on which the parties have agreed, then the parole evidence rule will exclude evidence that would change or contradict the terms of their contract. So, for example, if an integrated contract provides a payment term of $25,000, one party couldn't try to introduce evidence that there was an earlier agreement in which the parties really decided that the price should just be $20,000. Because the $20,000 term would contradict the $25,000 term as provided in the contract, it would be excluded by the parole evidence rule. A party would not be allowed to introduce as evidence that during negotiations the parties agreed on $20,000 because the integrated contract provides that the payment is $25,000. There are limits to what the parole evidence rule excludes. For example, if one party fails to pay as required under the contract, of course evidence of this failure to pay could be introduced into evidence. Likewise, if there is a term in a contract that might be ambiguous, such as the usual shipping terms, and we can't say for sure what those usual terms are, the parole evidence rule will not exclude evidence to explain that ambiguous term. Outside evidence might be allowed in to explain what the parties meant when they agreed on the usual shipping terms. Perhaps that refers to transport by truck, insured by one party or another. To summarize, the parole evidence rule applies to integrated written contracts, contracts with finalized terms. The rule excludes extrinsic or outside evidence, such as evidence from negotiations or even prior agreements that would be used to contradict or change the terms of the contract. The rule does not exclude evidence for other purposes, such as evidence to prove that a party failed to provide the consideration that it promised, or evidence for purposes of explaining ambiguous terms within the contract.
All right, I hope that parole evidence rule is clear to you now. Now let's talk about rules of construction. Once we get to the judge and he's trying to interpret the contract because someone has sued another, we look at our different rules of construction. How does he interpret or rule on this contract? Well, obviously, the first thing he will do is he will look at the express terms of the contract. What's that mean? He'll look at what the contract says. Now, let's say that a term is missing or a term is vague. Let's say, for example, you have to pay within 30 days as per the seller, but as per the buyer, their understanding is you pay within 60 days. Seller sues buyer. It's not in the contract how many days you have to pay. So the judge then could look outside of the contract and say, course of performance. They have made 10 deliveries under this contract during the year. How many times did they pay within 30 days? That is their course of performance of their contract obligations. Now, if they paid within 30 days every time up to the time of not paying till 60 days, the judges like to say, wait a minute, that evidence proves you understood you were to pay within 30 days. Now, alternatively, let's say it's only one shipment and they say, we're not going to pay for 60 days, 90 days. Well, if you'd had contracts over the past 10 years between these companies, the judge might look at the past dealings. What did you do in contract year one, two, three, four, past contracts? And if all those years you had paid, you, the buyer, had paid within 30 days, then indeed he's going to infer that you should have to pay within 30 days on the current contract. Now, let's say there's no evidence under course of performance, course of dealing. This is a brand new contract, for example, and there's been no payments yet. The judge then might accept evidence of usage of trade. In other words, what is common in this industry? So, for example, paying for food might be you have to pay within 15 days because it's perishable and you got to have cash flow to get more food, or, for grocery stores. But whatever the industry does, then he can look at that, he or she, the judge. Now, there's also this concept, we've touched on this once before about unconscionability, and that is sometimes a judge can set aside a term because it is so unfair. When you sign your lease, when you buy a car, et cetera, all the contract terms favor the one who drafted the contract and the one who is going to seek money from you. Well, if a judge says this term is really so unfair, he can refuse to enforce the entirety of the contract. He might just take out that one paragraph that is unconscionable or unfair. Or he might say, we'll apply that term, but only in a fair way. Now, we talked about the CISG already. We don't need to jump into this. There are probably 20 more, but as you're working in your future careers, here's some things that are wise to have in your contracts, sale contract, purchase contract, whatever it happens to be. If you're selling internationally, especially make sure you have a choice of language clause. The English language version of this contract and purchase orders, etc., apply. Number two, forum selection. What if I'm selling to someone in South Africa? Well, they don't deliver. I don't want to have to travel to South Africa and sue them there. I want to sue right here. I happen to be in Tulsa, Oklahoma. I want to sue in Tulsa, Oklahoma. So if my purchase contract has a clause that says anytime there's a dispute, we will hear it in Tulsa, Oklahoma, that's a forum selection clause. Similarly, I also will include a clause that says which law applies. And I would probably say U.S. Oklahoma law applies to my purchase, while they would obviously prefer South African law. And finally, there's a concept that you should include in your contract called force majeure, French term, and basically the meaning there is if indeed um, something happens that is beyond the control of either party, both parties are excused from performance or doing the contract obligations. What are some of these examples? War, boycott, pandemic, the ship burns up that's transporting goods, etc. These are all lightning hits and burns the plant down. These are all known as force majeure clauses. All right, that's it. I know you'd love to listen to more about so you can sleep well or drone off during this, but thank you for your attention, and we will see you next chapter.